Hey, this is David Black. I'm a criminal defense lawyer in Phoenix, Arizona. I'm going to give you the full details on what happens if you've been served with a protective order. First of all, what is a protective order? Second of all, what does it mean? What are my options, and what does it look like fighting it or not fighting it? So, what is a protective order? There are three main types of protective orders in Arizona. There are orders of protection, injunctions against harassment, and injunctions against workplace harassment. We're going to talk about orders of protection and injunctions against harassment. Workplace harassment is essentially the same as an injunction against harassment. So the main difference between an order of protection and an injunction against harassment is that an order of protection involves domestic violence or allegations of domestic violence. So what is an allegation of domestic violence sufficient to uphold an order of protection in Arizona? It is anything that establishes that an act of domestic violence has occurred in the last 12 months or could occur in the next 12 months. You've been served with an order of protection and you're like, I never committed any violence. I am a nonviolent person. Very well. Unfortunately, domestic violence doesn't require actual violence. It just describes section 133601 of the Arizona revised statutes, which includes any number of the enumerated statutes in there. Could include disorderly conduct, harassment, stalking, could include assault, any of those, as long as you have a domestic violence relationship. So a romantic relationship, a parent-child, a blood relative, roommates, those sorts of things. Now, an injunction against harassment, it has the same purpose. It's a restraining order is what it is, but it does not involve romantic partners. It involves non-romantic partners and an allegation of harassment. So you've been served with one of these two orders. What does it mean? Well, it means that you can't do certain things. You are restrained from doing certain things. So what are the sorts of things that this order can properly restrain you from doing? Well, it can restrain you from going places. It can restrain you from contacting people. It can restrain you from seeing your own children. It could restrain you from going to your own jobs. So these are some of the more serious things that it could do. Now, what can it do? It can't restrain you from protected speech. So the First Amendment is still very important and alive, as evidenced by a recent Arizona case that just came out in 2026. But the general idea is that we have a right to say certain things, but we don't have a right to contact people if the court says we can't contact them. So if you've been served, be really careful. I've had experiences with clients where I am talking to the plaintiff's lawyer and we are trying to work out some sort of deal or some issues for trial. And in the meantime, my client contacts the protected person. So what happens if you violate a restraining order? If you violate a restraining order, you can be charged with a crime called interfering with judicial proceedings. It's a misdemeanor in Arizona. It's a domestic violence crime. And suddenly you've gone from being served with this civil order that says you can and can't do these things to being charged with a crime. So we want to be very careful. What happens if the order is later found to be void or invalid? Well, it doesn't matter. If you violate an invalid order, it's still a violation of a court order. You could be charged with violating the court order later when judge says, you know what, we should have never given Sally a protective order, but you're still validly charged with this crime. So follow the order. Do not contact the person. If you have any questions about that, you contact a lawyer like me. All right. Now, you've been served with this order. You're not going to violate the order. You understand that even though you disagree with it, you have to follow it to the T. You have some guns. Can you have guns? Well, some orders say that you can't have firearms. And if the order says you can't have firearms, you can't have firearms. You got to turn them into the local police department if the order says that. If it doesn't say that, you give them to somebody else who keeps them separate from you. And that is until you challenge the order. All right. So what happens if you want to challenge the order? How does that whole process unfold? Well, we're going to take them basically in unison because orders of protection, we call them OOPs. OOPs are very similar to injunctions against harassment. I'll call them IAHs. So basically the OOPs and the IAHs, the hearings work pretty much the same. How long do I have to request a hearing if I've been served with a restraining order? Sometimes people call us and they're confused because they see 5 days and 10 days on the back of the restraining order regarding some sort of timing issue. But don't worry, those are not deadlines for you to request a hearing. Those are deadlines for the court to give you a hearing after you request one. You can request a hearing at any time during the valid time period that a restraining order is in effect. For domestic violence or orders of protection, it's 2 years. For injunctions against harassment, it's 1 year. You can request it at any time. And under some circumstances, the court has to give you a hearing within 5 days. And under all circumstances, it has to give you a hearing within 10 days. Now, does that usually happen? No. The truth is, usually you hire a lawyer, plaintiff hires a lawyer. Court says we can do it on day 9, but one of the lawyers can't make it, and the plaintiff's in Kentucky, and you're, visiting a sick relative, and we pick a date and we do that. But sometimes with exclusive use cases where husband's been kicked out of the house and can't see his kids, those the court will be serious, and they will say, no, it's on day 4, and that's it. We're doing it on day 4. We got to do it within 5 days. So at the contested order of protection hearing, what happens? At a contested order of protection hearing, only one of the two parties has to present evidence, and that's the plaintiff. So the plaintiff or the petitioner has gone to a judge and out of the purview of everybody else has said to the judge, Judge, I deserve this injunction or this restraining order because of A, B, and C. And the judge says, great, I am going to give you this order, but if the defendant who's served wants a hearing, you're going to have to come and prove it. And so you've requested that hearing. You go to court, the plaintiff has the burden of proving by a preponderance of the evidence that, in fact, for example, an act of domestic violence occurred or harassment occurred, which is a series of harassing acts over any period of time that would cause a reasonable person to become basically alarmed, and that, in fact, did cause that person to become alarmed. So plaintiff comes in, plaintiff presents her evidence. She says, Judge, on date 1, he sent me this text message. On date 2, I saw him sitting in front of my house. And on date 3, he yelled at my child, and then we, as the defense lawyers in this scenario, have the opportunity to cross-examine, right? And in that circumstance, we would say, yes, but that text message was reasonable. It wasn't harassing, and we weren't yelling. We were parenting, and at the time, we still had property at the house and we lived there. And these are all reasonable things and they don't amount to harassment. Well, if the facts as I just laid them out were accurate and the judge believed what we were arguing, you wouldn't have to testify and say any of this, and the judge would dismiss the order. Now, plaintiff may have a lawyer who comes in and says, well, the text said all of these horrific things. And in fact, there was no reasonable reason for defendant to be there at 3 a.m. and the yelling was out of line, and then it would be up to the judge. And so these are the types of things that happen at the hearing. If that were to happen, where I would be concerned that, I think they've established what we call a prima facie case that the restraining order is appropriate, then I would present evidence. I would put my client on the stand, and I would have my client explain to rebut some of the evidence that the petitioner presented. So if the court dismisses the petition and you're the defendant, you have an opportunity to request reasonable attorney's fees. That means that if you've paid us or another law firm, your lawyer can go ahead and ask the court to order the other side to pay it. Don't bank on it. I tell nobody to bank on this. There's no rule requiring the court to do this. The court can do this at its own discretion. It considers certain factors that are in Rule 39 of the Arizona Rules of Protective Order, and it can weigh them the way it wants. And as long as it procedurally does that, the Court of Appeals is going to uphold whatever it is that the trial court decides. Now, if you lose the order of protection, they'll reserve you with it because they may have modified it. They may have said, you know what, the kids shouldn't be on here. We're going to take the kids off. No act of domestic violence occurred vis-a-vis your children, but we don't think you should have contact with wife. And for some clients, even though the order of protection is upheld, a modification like that is a win, okay? Hopefully in a case like that, we're able to negotiate it in advance. Sometimes we can, sometimes we can't. Guns. If the court upholds an order and finds that you pose a serious risk respecting firearms, then there is what's called a Brady finding, and you may lose your right to carry a firearm. A lot of times, if you're going to challenge one of these things, the very first thing the court will say, and I kind of don't love this, I think it's I think if you have a lawyer, your lawyer should explain this to you, and it's maybe a way of trying to get out of doing the hearing. But a lot of judicial officers will say, right now there's been no finding, but if you have the hearing and you lose, there will be a finding, and you may be put on a list of people who can't carry firearms. And so you should know that that's true. Orders of protection, they're just a piece of paper. You've been served with a piece of paper that has been granted when one person unilaterally went and said some things without any evidence. It is not a finding. All right. Now, there are some consequences, though. In recent years, I've gotten calls from people saying, I wasn't going to challenge this, but I lost my TSA Fast Pass, and no longer can I bypass security, and therefore I want to challenge this. That's a good reason to challenge it. But sometimes it doesn't make sense. There is an order of protection or a restraining order. Is that a conviction? Does that go on your record? The answer is no. I mean, can the FBI find it? Yes. Could a qualified investigator find it? Yes. Does it mean anything? Not technically, no. It means that someone went into court and said some things and a judge found them credible without you there. That's all it means. It is not on your criminal record. Most of the people I've dealt with have never been asked if they've been served with a restraining order or an order of protection. So when somebody analyzes whether or not they want to challenge this, they have to consider all sorts of factors, but not so much the I must get out of this tone that some people think exists, that would exist with a criminal charge, right? Nobody wants a criminal record. Misdemeanor or felony, it's a bad thing. Orders of protection, restraining orders, they're different. They're civil orders that say, you can't do A, B, C, and D. Now they hurt our feelings, right? I'm well aware that people lying about us really hurts our feelings, or people telling the truth in an unflattering manner really hurts our feelings. But that's emotional. From a rational place, we want to ask, what is this stopping us from doing, and what is the real effect of this order on our lives? When we get retained by somebody who's been served with an order of protection, there are essentially two routes. One is less common, one is more. I'll start with the less common. Less common, we are able to look at the petition, which is the underlying substance of why you got the order served on you, what the plaintiff or petitioner said. Contact plaintiff's counsel and say, either A, you're going to lose, or B, we want to strike a civil deal. And we can do that. We can negotiate a contract that says, Jimmy's not going to contact Sally. He promises he won't do that. Sally's going to give back Jimmy's Nintendo Switch, and Sally agrees to dismiss the petition. We've had that happen. We've had it happen where we contact opposing counsel and we say, Sally's going to lose. This doesn't allege anything that would be supported. And then they just voluntarily dismiss it. That's obviously the hope, but it is not what usually happens. What usually happens is we have to go to what's called a contested hearing, which is a long word for a trial. So what do we do at the trial? We prepare. We get exhibits. We do investigation. We research the issues. Exhibits range from communications between a defendant and a plaintiff to items that we think that the plaintiff might use. We're not entitled to discovery. So one of the interesting things about practicing in protective order land is that unlike criminal law and unlike civil law, we don't get discovery in advance. We walk into the hearing as the defense, and oftentimes then and only then do we receive exhibits. Now, sometimes when there's a family court case and you're in superior court, you will get the exhibits the day before. We really appreciate that. We're able to do a better job preparing ourselves and our clients when we do that, but not always. I mean, sometimes we're literally handed a stack of documents when we get to court. So the things we can do is make sure that even if proven, the judge fully understands that these things do not warrant a protective order, that even though it's not directly relevant, usually you're not an ongoing threat to this person, that the order should be terminated. So this is obviously an aerial view of a large landscape, and everybody's situation is different. And we represent both defendants and plaintiffs, and some of these orders are very legitimate, and some of them are complete crockery. And I don't know which it is until somebody calls me and explains it. We will not take a protective order case without reviewing the petition, and we never charge to review the petition. So if you've been served with an order of protection and you should have been served with a petition or else service was not valid, give us a call. I will immediately ask you to send over a copy of the petition or one of the lawyers that I work with. We will analyze it. We'll tell you our honest opinion. We turn away more of these cases than any other, in part because of the fee shifting statute. We never want to be responsible for you incurring our fees and the other sides. But also, we like to win, and these are winnable. And when they're not winnable, there's no sense in challenging them. So we will be as direct and honest as we can. We'll analyze the case and tell you candidly if it makes sense to hire us or counsel generally. We can be reached at 480-280-8028. Thank you.